Welcome back to Court TV Live along with Julia Janae and Ted Rowlands. Perfect timing. We're in Virginia this afternoon. Closing arguments just getting ready to begin in the first grader shoots teacher civil trial.
Yeah, we're about to hear from the plaintiff's attorney, the one who's representing Abby Zwerner. She's a teacher who's suing the former assistant principal at the school where she taught. This is after a 6-year-old first grader had a gun on the campus and shot her, and she says that principal ignored warnings, and thus she's going to be suing her. We'll see for how much, but the initial lawsuit was for $40 million.
Zwerner shot in the hand and the chest back in 2023. All this happened in January. She had a collapsed lung. Let's go in. The plaintiff's closing argument has begun.
A gun changes everything. At least it should. And on January 6th, 2023, a gun walked on the campus of Rich Neck Elementary School. That gun changed the thoughts of every student who saw it, heard about it, staff member.
Your Honor, objection.
Objection.
It's not about the students.
You may proceed.
It changed what they did, where they went, and it changed one young woman's life forever. Except it didn't change the actions of one person. It didn't change where Dr. Parker went. It didn't change what she did. And those choices that she made to treat January 6, 2023 like any other day, even though a gun should change everything, is why we're here today. We're here today to ask you to do something that we can't do alone. And the thing that we cannot do alone is that we cannot achieve accountability by ourselves. That's what jurors are for. That's what you all are here to do if you find that accountability should be had. And you all may have different jobs when you walk outside of this courtroom. You may have different obligations in your personal life, but when you're in this courtroom and you walk back to that deliberation room, if you're one of the jurors that decides this case, your job is to deliberate together and return a unanimous verdict. And in doing that, one of the first things you all will do, if the judge hasn't already told you, is you're gonna pick a foreperson. And that foreperson's responsibility is to make sure that everyone participates in the verdict, that everybody's voice is heard in that room, that everybody chimes in and shares their ideas and talks about the evidence. And the reason for that is that the 9 of you who are here and the 7 of you who will decide this case are here as representatives of this community to voice their conscience of what's right. Just like yesterday was election day and we all cast our ballots, you all are here individually, but as part of this community to decide what should have happened on January 6, 2023. And when you're in that room and you're deciding these issues, there may be times where you disagree. And the hard part of this is you've been here for a week and a half and you get to know each other, and sometimes we can hear you laughing as you come out, which is great. And you've made friends. But when you get back into that jury deliberation room and you're talking about the issues in this case, and you're talking about how to decide something, you're gonna have to speak and share your thoughts. And we're asking you to fight. We're asking you, when you get back there, to fight for what you believe is the right outcome in this case. And when you're doing that, one of the instructions that I will point you to, and the judge talked about it and I talked about it earlier when we picked the jury, is the burden of proof. We talked in voir dire, if you remember, we said this isn't a criminal case where you decide things beyond a reasonable doubt, and I may have done this with my hands depending on which group you were in. I say this is a case you decide on the preponderance of the evidence. And I show you this because when you get into that deliberation room and you're fighting about issues or you're trying to decide something, and look, I hope you get back there and everybody takes a straw poll and says, you're with us. I hope it. And we've put on enough evidence, I think, that that may be true. But as you're deciding those issues, this is where you come to. This question of what's more likely true than not true. That's the burden of proof in this case. And so with that, I'm going to take a step back and I'm going to give you a roadmap for what we'll talk about. This is called summation. It's my chance to tell you all what I think the evidence was, but you all were paying attention. You all took copious notes. And candidly, if the judge lets you, I'm sure you could come up here and give closing arguments yourself and tell us what this case was about. I think you know it that well. So my goal here isn't just to tell you what you heard from that witness stand or what you saw on that TV. My job here is to try and talk ideas so that when you get into that room and you're having those discussions, you have an idea of, okay, how do we resolve this? What are tactics that we can think through and process, and how do we answer these questions? And some you may like, and some you may not, and that's okay. That's my job so that I can help you do your job in that room in however long it takes us to get there. So what I'm going to do is I'm going to move pretty quick. We've already talked about your job. I'm going to move quick through the second stop, which is what I'll call fault, and we're going to focus on what Dr. Parker's job was. Then I'm going to talk about the blame game. And then if you'll let me, I'm going to slow down and I'll talk about costs and consequences at the end. And the reason I slow down is that it sounds like we're going to go fast, and we're going to try and go fast through the first part, but I don't want to lose grasp of what we're really here for. And that's to talk about the effect that this has had on Miss Zwerner. Sound good? All right, if we can go to the PowerPoint. So, your roadmap: fault, blame, and costs. Fault. Her job is safety. Dr. Parker's job is safety. We talked in opening statement about promises. Do you remember that when Ms. Toscano came up here and we talked about expressed and implied promises, the things we say and the things that are meant with what we say? And when we get out onto the road, I know a lot of us don't have keys with keys anymore, but there's still keys out there. I have a 4Runner. You put that key in the ignition, you turn, and as you go out onto the roadway, you're making a promise. You don't have to say it to people, but what you're saying is, by strapping your seatbelt and going out onto the highway, you're saying, I promise to look out for you. I promise to see the stop signs that are there to be seen. I promise to stop at those stop signs. I promise to turn my blinker on when I go to change lanes. I make these promises because you rely on me to make the promise, and I rely on you to make the promise, so each of us can go home at night and see our families. We make those promises even though we never say them out loud. And then there are promises that come with what we say or how we say them. There are promises when you answer the phone and agree to take action or to find something out. And then the question becomes, what happens when you put the phone receiver down on the table and you don't meet that promise? That is what the judge was talking about when he instructed you on what's called Instruction 16. And this is the law to govern you in this case. It says a person who undertakes gratuitously or for consideration, in other words, whether you're paid for it or not, to render services which she should recognize as necessary for the protection of the third person, is subject to liability, talking about fault, to the third person, in this case, we're talking about Ms. Zwerner, for the physical harm resulting from her, Dr. Parker, failure to exercise care to protect her undertaking. So what does that mean? And we'll get through some of this evidence in a moment. Whether it was on a phone or through a doorway, around noon on January 6, 2023, there was a communication. And that communication involved a gun and a backpack. And she answered the call. And the question that you have to decide now is, by answering that call, by making the promise that I'm going to find something out, explicitly or implicit, we can talk about other promises later, did her failure to exercise reasonable care, in this case, did her failure to act, to do something, increase the risk of harm to Ms. Zwerner? Or, it's an or question, not an and, did Ms. Zwerner suffer harm because she relied on the third person? That is, she relied on somebody to act. That's our framework, right? That's what we're talking about in this case. That's the law that governs your decision. And let's talk about facts as they come through them. You're gonna hear, before I do that, I have to explain this thing of negligence that we talked about. We've heard this word negligence. We've heard the judge talk about gross negligence. We'll look at the instruction a little bit later. Best way, I know how to explain it, okay? Hang with me. If I had a baseball and I turned around, sorry, Keith, Mr. Williamson. If I turned around and I thought, I'm gonna try and hit that gavel off the top. Actually, I'm gonna change my mind. I'm just gonna point right at Mr. Williamson's forehead. And I threw that ball, meaning to hit his forehead. That's what we call an intentional harm, right? You get it? I meant to do it, and I did it if I threw the ball. Negligence is knowing I'm not as good a baseball player as probably the judge. If I looked up at that gavel and said, or maybe that apple, said, I can probably hit that. And I...
Okay, a bit of breaking news to pass along out of the state of Arizona. The dad who admitted to playing video games while his daughter was left in a hot car has died. Christopher Schultes was supposed to be taken into custody today as part of a plea agreement. He failed to show up in court, and his attorney and prosecutors appeared to be concerned and very emotional in court today.
Yeah, this information just coming in, and just 2 weeks ago, Schultes has pleaded guilty. We reported that here on Court TV to a second-degree murder charge and intentional child abuse in the death of his 2-year-old daughter, Parker. The criminal complaint said that the temperature inside of that vehicle in Arizona back in July, it was 109 degrees Fahrenheit. He was looking at spending between 20 and 30 years behind bars as part of the plea agreement. And the judge has reaffirmed that that sentencing date was going to be held on November 21st. Now, Court TV is going to continue to follow this story and get you the details. We don't know the cause of death at this time, but we will get you back inside of that Virginia courtroom after this quick break.
Here you are, responsible for the lifelong torment of an entire family. Is that evil in your mind now? So now you've taken her mother's life, and you heroically step in to console her.
I knew it was wrong, but yeah, I still did it.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Ms. Kovac was in my room investigating the situation. She was observing the student sitting next to the student, and at that time, I'm trusting Ms. Kovac.
Did you remove JT from your classroom as you had done 2 days prior when you took him by the hand and took him out?
No.
Did you remove his backpack from the classroom?
No.
Did you search his backpack?
No.
Did you go back to the security officer in the lunchroom?
No.
That is the plaintiff, Abigail Zwerner, being questioned last week when she took the stand about her actions after she became aware that one of her 6-year-old students may have had a gun at school.
Yeah, it turns out that student did bring the gun, and it was inside of his pants. And eventually, that would turn into a shooting of the teacher. Zwerner was shot through the hand and the chest that resulted in a collapsed lung. She did survive, and she is suing the former assistant principal, Ebony Parker, for millions because she says that Parker should have taken action that day in order to prevent the shooting.
Let's go back into the courtroom now. We're listening to the closing arguments, starting with the plaintiff.
And I threw it and I hit Mr. Williamson. I didn't mean to do it. I didn't intend to hit him, but it was not the wisest choice. Opposing counsel said at one point in opening statement, it was inadequacy. Remember that line? It's not indifference, it's inadequacy. We'll come back to that. It's not quite what I should do. Gross negligence. If I turn around, sorry y'all, and I decide I'm gonna try and throw the ball to Mr. Bright. And in between Mr. Bright are Ms. Zwerner and Ms. Toscano. The risk of danger has gone up, right? It's gonna be harder for me to throw that ball. And the truth is, I ain't that good at baseball. And so there's just as good of a chance that I throw it at him or I hit one of these two. That means I'm kind of indifferent. I may get it done, I may not. That's what we call gross negligence. The risk of harm has increased, and I'm somewhat indifferent to the outcome. And then we talk about recklessness, which is in one of the instructions. Recklessness is saying, I'm gonna try and hit that back wall through that crowd of people, and by golly, I hope I do it, knowing the likely outcome. So we have levels to this, if you want to think of it that way. And the question is, how great is the danger? How great is the harm, the risk of it? And when I act or fail to act, how likely is it that something's going to happen? So, we've seen a lot of faces. We've heard a lot of testimony. I told you I'm not going to go through everything, but let's go through this. I told you at noon or around noon that day, there was Miss Kovac was told that by two girls that there was a gun. What we know is that Miss Kovac shared that information with Dr. Parker. And what I'm going to come back to throughout this closing argument, throughout this summation, is that every minute matters. Every minute matters. Ms. Kovac says, we think the gun's in the backpack. And according to our expert, Ms. Shufflebarger, as you remember, at that moment, a gun changes everything. A gun changes everything. You stop and you investigate. You get to the bottom of it. You get to the bottom of that backpack. You get to the bottom of his pockets. Whatever it is, you get to the bottom of it to know whether that gun is real and on campus so you can deal with it. But that's not what happened. So later a communication comes back. We think it's put in the pocket. And then the check of the backpack happens, and it's gun out of backpack. And this is where we have the line, there are little pockets. It's a line that we heard on the stand. It's a line that you just can't forget when you hear those words. And then you have search the person, and the response is check the bag. And I want to stop here. By this point in the day, Miss West has asked Mr. Sims to ask Dr. Parker, have you searched the person? And when that communication is read or brought to Dr. Parker, what do we know? We heard in the instructions that evidence can be proven by direct and circumstantial evidence. What does that mean? I don't need to see the rain coming down from the sky to know it's raining if I walk out in the morning and there are puddles on the floor, right? I don't need to see the rain. I know it rained. And when Dr. Parker says, in response to, did you search the person? We checked the bag. What that tells us is that that was a real threat. That it was accepted as true, so much so that we needed to check the bag. All this talk about we didn't think it was a real threat. It wasn't a credible threat. Why are you agreeing with Ms. Kovac to search the bag if you don't think it's real? And when they say, did you search the person? And the response is, we already checked the bag. Guess what that tells us? We thought it was real, and we don't know where it is anymore. We don't know where it is anymore. And then the boy outside of Miss West's classroom crying, remember? Crying, not wanting to go back into Mrs. Z's classroom where he's supposed to be. Says bullets and shoot. The boy showed me bullets, JT showed me bullets, and he said if I told anybody, I would shoot. Bullets, shoot, gun. The only way you can shoot a bullet is if you have a gun. And to tell us that telling a boy that he will be shot is not a threat, not a threat, goes against the very language that that 6-year-old used. And then he goes and has a conversation with her again. You heard from Miss West, who said he was crying scared. I talked about R a moment ago. He was crying scared. And I suspect what you're going to hear from the other side is, well, we didn't get good information. Remember that from Dr. Klinger? Well, we didn't get good information.
Need a break. First, Franz Borchardt watching from back home. Your thoughts on this young man delivering the close and overall of the case?
I think it's a good closing. I think he's doing just what he suggested. He's making a roadmap. I think the elephant in the room that he needs to address is essentially the plaintiff is making this defendant the scapegoat for a shooting. And what he cannot say, the law doesn't allow him to say it, Ted, is, hey, it's not like she's going to have to reach into her purse and pay if you rewarded a judgment. Insurance is going to pay it, right? And jurors are always reluctant to put all of this on the backs of someone when there's a shooting and it's not the actual shooter. They're reluctant to make that person fully responsible. So he is going to have to, at some point, address that without addressing it. Now, that said, he's doing a bang-up job, Ted, and I think he is moving towards the finish line of prevailing on the case.
With that piece that you just said, Franz, about the insurance not being able to be mentioned, do you think that will impact what they ask this jury for when it's all said and done?
Well, you can ask, Julia, you can ask for the sun, the moon, and the stars, but I think ultimately they're asking for a big number regardless. But the reality is, one, she survived. Two, again, I come back to this point in the road of how responsible is the defendant, if she's responsible at all. So do you ask for an astronomical number because essentially you ask for an astronomical number? I think it will address it, but at some point he may argue, her ability to pay, isn't something you should consider, even though they all are going to consider that.
All right, let's get a break, and when we come back, we'll pick up the plaintiff's closing argument where we left off and look forward to what the defense will say when they have their opportunity. Stay with us. Let's head back to Virginia now. We're watching the closing arguments in the first grader shoots teacher civil trial.
Yeah, this is a former Rich Neck Elementary School teacher, Abby Zwerner. She's seeking millions in damages after a student, a 6-year-old, shot her back in 2023. And this lawsuit claims that there was gross negligence in the principal not preventing the shooting, alleging that this assistant principal, Ebony Parker, ignored several warnings that the student had a gun on campus.
Let's go back in the courtroom now, pick up the close from the plaintiff's attorney.
We didn't know that he was crying and scared. Somebody should have told Dr. Parker that he was crying and scared. When we go out onto the road and there's a stop sign on the corner of the street, tuck it behind a little corner or right there for us to see either way. It's our job as we're driving down the road to see the stop sign. It's our job to look out for the stop sign. It's our job to find the rules of the road and the signs of the road so that we can then govern our behavior. It was Dr. Parker's job to investigate. The manual that governed their relationships amongst each other told her that you must first assume it is credible unless analysis suggests differently. Cause the student making the threat, if known and on campus, to be immediately removed, pending further investigation. What does that mean? That means you can't stick your head in the sand. You cannot stick your head in the sand and then come into court and say, I didn't have the information, when it was your job to find it, when it was your job to look for it and to do the investigation and to talk to that little boy who saw the gun and to talk to those 2 little girls who talked about the gun and to talk to all of these people. If it's your job to investigate, which their handbook tells them it was, you can't come into court and say, I'm going to close my ears, close my eyes, put my head on my desk, and then use that as a defense to my case. The law says you know it because it was there to be known, because the stop sign was on the corner of the street and it should have been seen. It's no excuse to walk into court on a traffic ticket and say, well, Judge, I didn't see the stop sign. The stop sign was there. The stop sign was there. Feet, yards from her. And then, in my view, you turn up the dial. Because at this point in the afternoon, there is a accumulation of information. We saw a gun. It was supposed to be in a backpack. We don't know where it is. It might be in his pocket. It was shown to a boy at recess with bullets. We still don't know where it is. He's crying, won't go to class. And another request. Can we search the person? And I suspect they'll come up here and they'll say, well, Mr. Rawls told you that he didn't think it was credible. My response to that is let's look at actions. because our actions speak louder than our words. Did we hear any other evidence of Mr. Rawls coming and asking to search just kids at random when he didn't think there was a threat? We talked, and all of the evidence is that searching, and even Dr. Klinger told us, searching a child is something that you do delicately. You only do if it's necessary. That's what they're taught. And he came to her directly and said, have we searched the boy? Again. And he wasn't the only one in that moment. Because in that moment, when she heard, West heard, that they had not searched the person, Mr. Sims goes and stands outside the door of Mr. Rawls and Dr. Parker and says, are we searching the person? That's 3 times somebody is asking her to do this. 3 times. Countless times where we're talking about the boy throughout the day and the gun and where it is, but 3 times to search the boy. That should be flashing at you to act. And the response? Let's hold off. Let's hold off. It's 1:40 in the afternoon. Mom's gonna be here at 2:30 p.m. to pick him up. Let's hold off. I told you that I would talk more about promises, right? When Mr. Rawls walks down the hall, being told directly, let's hold off and wait for Mom to come and then we'll take the action. What does that tell us, like the rain that we did not see? It tells us that she still thinks there's a gun. If she doesn't think there's a gun, what are you holding off for? If you don't think there's a gun, you don't say, we'll wait for Mom to come and we'll do the search. You say, there's no gun. Let me go back to my testing. It's that creeping thought, that knowledge that there is still a gun on campus that leads to somebody saying, we probably still need to do something, but let's hold off. Every minute matters. Every minute matters. And they'll say, no, that's not what she thought. That's not what she knew, right? We had a time with Dr. Klinger, weapon, firearm, we'll talk about that in a second. The very first witness in this case, and it's sometimes hard to forget because it's a week ago, the very first witness in this case interviewed Dr. Parker within days, in January of 2023, of this incident. And Dr. Parker herself said the students reported a gun in a backpack. You don't take my word for it. Take hers.
Let's get a break. We'll get more from the closing arguments on behalf of the plaintiff when we return, and then it'll be time for the defense.
Here you are, responsible for the lifelong torment of an entire family. Is that evil in your mind now? So now you've taken her mother's life, and you heroically step in to console her.
I knew it was wrong, but yeah, I still did it.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific, only on Court TV.
Back to court in just a minute, but first an update out of the state of Tennessee in the Broke My Heart murder trial.
Yeah, it's day 2 in this live trial we've been following. The defendant is Latasha Daniels. She's accused of fatally shooting her married pastor boyfriend. She was the girlfriend after their long-term affair turned sour. The pastor's wife was also shot but survived.
Earlier today, a detective who interviewed the wife testified that she initially told him that Daniels only shot her after she went to protect her husband.
Going back to your interview with Miss Perry at the time.
Okay.
Chaplain Perry.
Yes.
You also found out that she had been shot.
Correct.
And you also found out that she didn't believe Miss Daniels had tried to shoot her.
I don't recall that. I recall Mrs. Perry telling me that she tried to cover her husband to protect him, and that the defendant shot her.
We are having to juggle these trials, so we will keep you updated on the Daniels one there in Tennessee, and you can stream it right now live on courttv.com. But we do have to turn our attention back to Virginia, where those closing arguments are underway in the civil trial connected to a lawsuit involving a former elementary school teacher.
Let's go back into the courtroom and pick up the closing argument on behalf of the plaintiff. We'll pick it up where we left off.
At 12:20. And that at 1:40, there were still concerns of a weapon on campus. Her words to the school system as part of the investigation. Not my words. That means for an hour and 20 minutes, and we still got another 20 before Miss Zwerner shot. There is a gun on campus. And they come up here with Dr. Klinger and say, well, she needs more information. What more do you need? You knew who, you knew what, you knew when, you knew where he was all day. You knew when he was in the classroom, you knew when he was on the playground, you knew when he was back in the classroom. What more do you need to act when a gun changes everything? And this is no time to play name games. This is no time for, well, maybe the child said bullets. Is bullets really a gun? Ladies and gentlemen, if you have an elementary school, 6-year-olds, if we looked at the classroom walls, we're still teaching them how to use punctuation correctly and what words to use and how to capitalize letters. And you're gonna wait until a boy says, no, it was a gun, it was a real gun, it was black, it had bullets in the gun? No, ma'am. Gun, bullet, weapon, firearm, we don't need to talk about what all they mean. Each of them required a response. Each of them. But what we know for certain is that it was a gun from her herself. And they're going to come up here and tell you hindsight 2020. Remember that? Hindsight 2020. It's easy to see now that there was a shooting, that we look backwards and now that we know there was a shooting. It's easy to know that looking at our rearview mirror. You don't need to look in the rearview mirror. There were road signs in front of Dr. Parker for an hour and a half, screaming at her, flashing at her, telling her exactly what was going to happen if she did not act. You do not need to look in the rearview mirror to know what's coming ahead. And the only reason it's in her rearview mirror is that she blew past the signs. She blew past the signs. Do we need every letter to know what it means? Do we need every letter? They're going to tell you this wasn't foreseeable. Remember that discussion? Wasn't foreseeable that this would happen. And that's why we talked about this question of foreseeability. And I'll show you an instruction on this. This is instruction 17. The defendant is not required to have anticipated or foreseen the precise injury, but it is sufficient that a reasonably prudent person would have anticipated or foreseen that some injury or damages might probably result from the negligent act. What does that mean? What that means is, and what they're going to try and argue to you is, Who could have seen that a 6-year-old would pull out a gun from his pocket, point it at a teacher, and shoot? That's not the question. The question is for every moment, every minute, every second that a gun is in the possession of a 6-year-old who, I agree, has totally unpredictable behavior. If anybody has dealt with 6-year-olds, it's totally unpredictable. All the more reason to find the gun. All the more reason. That gun could have been popping up and down in his jacket and gone off. Handed it to a friend and gone off. Showed it to a friend and a book hit it and gone off. Dropped on the floor and gone off. You do not have to foresee the precise injury that was caused. Only that some injury or damages might probably result. We can go to the...
All right, the closings continue. This is crucial because it's such a nuanced case. Franz Borkart watching along with us. Your overall thoughts, anything standing out as you listen to this close?
So I like the way that he has drawn the parallel to what is otherwise a very complex, very complicated negligence question to a car accident. Blowing by opportunity, looking in the rearview mirror, I loved it. I thought that was very masterful, bringing it down to a very edible, very, very edible level for these jurors. And look, I can understand being very frustrated at why didn't you just go look at the bag or in the bag? This seems so preventable. That said, I'm at the edge of my chair because I kind of want to know what they're going to respond with this. Was the policy and procedure such that they weren't going to look in the bag? So I think both sides are doing a really good job, Ted. And look, this is good lawyering.
Franz, do you think the defense is going to embrace the negligence but tell these jurors this was not gross negligence? We know they're in Virginia. There's this immunity for officials, public servants who are simply negligent. But gross negligence goes beyond that, and that's what the plaintiff has to show. And I don't know that I'm hearing enough yet to make sure these jurors know the difference.
So I think Bon Jovi put it best when he said, "My love is like bad medicine." And that's the argument, right? It's a tough argument to say, hey, we're responsible, but not responsible because of this immunity law. If it were me, that's how I would lean in, Julia. I would lean into that. My concern, however, is never underestimate the possibility of a jury nullifying and saying that may be what the law is, but we're going to reject your bad medicine and we're not going to take it. Mm-hmm. So would I do it? Yes, but there's certainly a risk involved in it.
Oh, yeah. Good point. We will see what happens. Franz, thank you so much for all of that analysis. We've got more of these closing arguments ahead. And the first grader shoots teacher civil trial for Abby Zwerner. Don't go anywhere. We'll be right back. Welcome back to Court TV Live. I'm Julia Janae along with Ted Rollins. Thank you for following along with us as we are in Virginia this afternoon. Closing arguments have started in the first grader shoots teacher civil trial.
Plaintiff Abby Zwerner is suing former assistant principal Ebony Parker for millions after Zwerner was shot in January of 2023. The lawsuit alleges that Parker ignored the 6-year-old's behavior when a 6-year-old showed up to school with a gun and failed to act after some warnings had erupted at the school.
So the plaintiff's attorney right now is arguing in front of this jury that she is responsible and should be getting to the amount that they are going to ask this jury. It's a civil case, so plaintiff goes first and then the defense. Let's pick it up where we left off.
And for 2.5 hours, this thing was beeping on her radar. Beeping. I use this as a metaphor to talk about what we just talked about. Because the focus here is a gun in a 6-year-old's hand. But I want you to think for a moment. Imagine there was a gun sitting right here on the playground at an elementary school. And a student comes up and says, there's a gun on the playground. Isn't the danger apparent just with a gun near the proximity of any of these agreeably unpredictable children? Isn't that the danger? Because the gun is what changes everything. And you may hear, well, we don't know if it was a real gun. We don't know. I think we heard from Dr. Klinger, maybe it's kids talk about squirt guns all the time. Really gonna take that chance? Really gonna take that chance? I have friends that like to play roulette. When they go up to the roulette table and they throw that ball and they put their chips on whatever color they want, you know what they've already decided? Win, lose, or draw, I'm indifferent. That money's gone. If I win, great, I'll have a great night. If I lose, I've already accepted the fact that I've lost. They are indifferent to the chips on the table. They are indifferent to the odds that are before them. And if you're willing to gamble on a real gun or a squirt gun at an elementary school, you are indifferent to what happens next. You're going to hear from the other side, and I'll point this out to you in an instruction, this question of gross negligence. It's instruction 13. The degree of negligence which shows indifference to others that constitutes an utter disregard of caution amounting to a complete neglect of safety of another person. Indifference. And the other thing that you'll find in your instructions, and I'll point this out to you to say, a gun changes everything. I've said it many times. I'll say it again. That first time, that first moment, not acting is indifference. Every minute is indifference. But even if it was just me trying to hit the apple instead of me trying to throw the ball at Jeffrey, even if it was not indifferent the first time, you follow? Even if the first time wasn't indifferent, what the law says is if I keep trying to throw the ball and hit Mr. Williamson, and every act of that attempt is its own negligence, those add up. And you start to wonder, what are you thinking? Why do you keep trying to throw the ball and you're not getting the outcome that you're trying to achieve? And so each minute, I said every minute matters, because each minute in which there's nothing done, in which the actions that she's supposed to take are not taken, in which she's not ensuring the safety of the people on that campus, each minute adds up. It adds up, even if each one of them on their own is an indifference. Go to the PowerPoint. Care is a verb. Care is a verb. What do I mean? It means that when you hear from the other side that she did something, she cared enough to acknowledge that there would be a search. She cared enough to say, well, we'll have a plan to search the boy when the mom gets here. That those acts of caring, those feelings of caring are enough. The response is, care in the law is not a feeling. Care in the law is a verb. It's an action. And the question is, what actions did she take in an effort to meet her obligation? Part 2, blame game. We'll go quick. This is the defense. Mistakes were made, but none by me. All right, let's point the finger at all of these other people and say that they did the wrong thing. And I told you guys in voir dire, if many of you might remember, I said, look, at the end of this case isn't about the parents, this case isn't about other people, the question's just gonna be whether she was grossly negligent or not. And that doesn't deter them. They're pointing the finger at everyone that they can point the finger at to try and deflect responsibility and play the name game. And the issue with that is that each of those people that they're trying to point the finger at had a piece of the puzzle on January 6th. They all had an element of it, whether it was the backpack or whether it was the bullets or whether it was the shoot or whether it was the search. Each had a piece of the puzzle. But you know who had the entire puzzle? Dr. Parker. Dr. Parker. And what they're doing is that they're telling you that, well, these individuals should have investigated. Ms. Kovac should have investigated. Ms. Zwerner should have pulled the kid out of class. Ms. West should have done something else at the parking lot. What the policies tell us in their agreements with each other in terms of how they're going to operate at the school is that those were all her job. And so what they're saying is Dr. Parker dropped the ball and they want somebody else to pick it up for her and do it. That's not right. And every time they come up here and say that XYZ person should have done something different, that Ms. Kovac or maybe Mr. Rawls should have searched, just tilt that rearview mirror and look at it yourself. Because every finger that's pointed at somebody else by the other side of this case should really be a finger pointed at themselves in the mirror. What their job was, these staff members, was to be watchmen and to sound the alarm, and it was the job of administration within each of these policies to answer the call and to come and to do something about it. And each of them sounded the alarm, and they waited on the cavalry, and no one came. I told you I'd tell you about that moment where he said, hold on. Remember the moment Mr. Rawls says to Abby, hang tight. Hang tight, we're coming. Every minute matters. And what Mrs. Zwerner should have seen coming through that door was the help that was promised to her. That we're coming. The cavalry is on the way. The first time Ms. Zwerner saw a police officer on January 6, 2023, should have been when they walked through that door, not when she was laying on her back in the administrator's office. Told you I'd pause. Pause. I don't want to rush through this. I'm going to try and be efficient, but I don't want to rush through this because it's so important. Costs and consequences. This is the part that we talked about in voir dire, and I said, how do we come to this number? How do we come to an amount of money? How is that done? And to some of you, I said, we'll go through it. I'll give you tools or I'll give you ideas, and we'll talk about the law, and we'll get you there. We'll make sure you understand what your job is and how to do it. And so with your permission, I'll start with a statement that I hope I suspect everyone agrees to. Everyone in this courtroom. Everyone in this courtroom. There is no material item, possession, object on this earth that is worth more than a human life. Not a single one. You're not supposed to watch the news, according to the judge. You can still watch the news. And last night I was sitting and I was watching the news and I saw the news of a plane that crashed outside of Louisville, Kentucky. A UPS plane. And you know the first question that the newscaster asked? How many lives were lost? He didn't ask, well, how much the plane cost? Or was it holding freight? Or what was the freight? Or what was in the plane? First question, and the first question that each of us thinks, whether it's in our gut, in our head, or out our mouth, is how many lives were lost. And that's because there isn't a single thing on this planet that is worth more than a human life. So we start there. And then the question is, how do we value? How do we count the value of a human life? Well, over time, we've come up with phrases that we use every day. We use phrases like time is money. Heard that one? Time is money. We hear phrases that started in the 1600s and the 1700s that say, can I have a penny for your thoughts? Or, is it worth my time? All of these questions tell us that we understand that there is a value, a dollar sign, as weird as it seems to think about it, that we equate to our human experience, that we count in minutes, hours, days, weeks, months, years. And you heard it in this courtroom. We had experts take the stand, and they were asked, how much are you being paid for your time? Remember that? $500 an hour to be here.
All right, we're just about to get to the number. What is he going to ask this jury to come down at? It's a difficult one, part of the close, because it can be off-putting to some jurors.
Can be good use of the current event there.
Yes.
Towards the end to really get jurors thinking about responsibility.
Let's get a break. More of the close from the plaintiff when we return.
Tonight on Closing Arguments, will an OnlyFans model accused of murdering her boyfriend be released on bond? We have takeaways from today's hearing in the case against Courtney Clenny.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific, only on Court TV.
Let's head back to Virginia, where a teacher is suing a former assistant principal for millions. 28-year-old Abigail Zwerner is suing the then assistant principal of Rich Neck Elementary School, Ebony Parker, after she says that Parker failed to act when a 6-year-old showed up at school with a gun.
Now, we know that 6-year-old ended up shooting the teacher, something that just shocked everyone. But the teacher is suing this assistant principal for not doing more, for not making sure that this child had been searched on his person that day, even though his backpack was checked. Let's get you back into the courtroom now. We're still listening to the plaintiff's closing argument in front of this jury.
Dr. Klinger took the stand for about 2.5 hours, more than $1,000, sitting in this courtroom, talking about life experiences that she lived. And nobody blinked an eye. We understand, whether we ever think about it or not, that there is an equation, that we can equate human life and our experiences to dollars and cents. And it's my job to try and talk to you about that, and it's ultimately your job to decide how much it's worth. So, the jury instructions will tell you what I call what buckets or elements of damages to think about. And when I say that, I mean these 4 things right here. And we'll take them in order. And I'll tell you that I'm going to merge some of them. So we're first going to talk about bodily injuries, disfigurement, and deformity. The law says that if she is entitled to recover, that is, if Ms. Zwerner has proven her case, that she's entitled to recover money for each of these elements. So why did we put on the evidence? Why did we, if we can go back, put on the evidence of these 3 doctors and other doctors that came before you? It's to show you the injuries. To show you the injuries so that you could understand, based on the jury instruction, how bad, how severe, and duration, which is what the jury instruction says. How long will this be? And this is what we talked about. That a bullet pierced through her hand, into her rib, through her lung, and that it pooled. Remember that from Dr. Munn? That it pooled and it collapsed her lung, but that cavity is still in her body. And because that cavity is there and that bruising comes through, we talked about scar tissue. Like you pull a muscle and it never goes back to the way it's supposed to be. And it stays that way and it affects the way that they can breathe. And it pierced through her hand. We had pictures of the fragments that were through the wrist. And we talked about the issues with the thumb and the index finger and the middle finger. And you heard Dr. Anderson tell you that this is the type of injury we see in war. That it's devastating. And that even though the bullet made its way through the hand and into her body, it still rests there today. And it still rests there today because it is 2 centimeters. 2 centimeters from her aorta. She was 2 centimeters from death. And that's never going to change. It's never going to change. It's there forever, and we talked about the surgeries that were done, and even to this day, she sits here with a piece of metal on her finger. Not because she did anything wrong, but because this bone still will not heal. And I will tell you, whether that bone heals or does not heal, we know for certain her wounds, all of them, will never go away. Don't we know that? Don't we know that even every moment she goes into the doctor's office and has concerns about what her medical condition might be, and she has to tell them, I've got a piece of metal 2 centimeters from my aorta, I can't have that test. I can't do that thing that I might need. And so when we talk about bodily injuries and their severity and their duration, what we're talking about is how bad is it in the way that it affects somebody's life every day. And if you can't open a chip bag, and somebody might say on the other side, it's just a hand. It's just a hand. Is it? Is it when you return home from surgery in the hospital and you're with your mother, and we're talking about disfigurement and deformity, and you can't move your hand, and you can't bathe yourself at 25 years old, you can't use the restroom by yourself. Are we just talking about a hand? Or are we talking about what it is to have dignity and be a human being? The element of instruction talks about mental anguish. It talks about physical pain and mental anguish. But I'll tell you right now, physical pain, she felt more than anyone could ever imagine. I promise you that. And we showed you videos to try and tell you and show you exactly what it was like. But even when the pain goes away, or goes down. This doesn't. This keeps going. And we heard from Dr. Watson, and we spent time talking about re-experiencing. Do you remember that? And I had a roadmap stop with Dr. Watson that said brain and body. Remember that? Brain and body. Why did we talk about brain and body? Because you don't injure part of a human being. You don't just injure a hand or an arm. You injure all of them. You change all of them. And what we heard about and what we talked about is a young woman at 25 years old, who had chosen her way of life, who had decided who she wanted to be, where she wanted to go, and the purpose that she would achieve. You heard from her sister that said she had a purpose. She knew what she wanted, and she was chasing it at 25 years old. And some may say, do you want to be a teacher? Really? That's what she wanted. Maybe it's because her mother did it. Maybe it's because she wanted it for herself. But that was her choice. And they'll talk to you about cosmetology school, like she had considered this beforehand. Really? Really? She chose to be a teacher knowing full well from the experiences of her mother exactly what it meant. That it meant sitting with a printer next to you while you sat next to your sister and she watched movies. That it meant late nights. That it meant early mornings. That it meant difficult times with your students. That it meant being around them and shaping the future of our country. And I'm not saying that to you to tell you that being the teacher is the most valuable thing in the world. What I'm telling you is that it was her choice. It was her choice, and her choice to be what she wanted to be is changed and taken from her. What do we value that at? What do you value it at when you decide that this is who you're going to be in life? And through no fault of your own, against your will, and without your consent, that's taken from you. That dimming of a light of a young woman who used to pop at you with color. That numbing.
All right, we'll get a break, but first, Rob Corbett watching along with us. He's in Charlotte, North Carolina. Your overall thoughts of the case and specifically this close from the plaintiff?
Well, first off, thank you for having me. Regarding this case, I do think it is an interesting case. It is interesting in terms of who the plaintiff has chosen to bring this lawsuit against. We've seen cases in the news of where the parents have been charged criminally because their son brought a handgun to school and someone was injured or killed. But this is interesting in that it's not the parent who's being sued. It's not even the first person who was necessarily made aware of the possibility that the child may have had a gun, but it is the assistant principal. Regarding the closing, I do think that the plaintiff's attorney, he's doing an excellent job. He is incorporating the jury instructions, because when you are dealing with something that is complicated like this, it is important to draw the jury's attention to the instructions so they know what law they are being asked to apply in a particular case. But notwithstanding that, I do think it is an uphill battle for the plaintiff, because once they get into jury deliberations, once they start talking, because at this point, juries have an idea in terms of which way they are leaning, and what you want for closing is sort of provide guideposts to sort of tell them that if you are already leaning this way, this is what you need to hold on to, and this is what you bring up during deliberations. But I think it's an uphill battle because, you say the saying, when the rubber meets the road, you're going to have people who are ultimately going to say, She is not the parent of the child. She did not know this child brought the handgun. She is not the one who did not keep the gun secure so that the child brought the gun. The book bag was searched, but the child's person wasn't searched. I think those added together is going to cause, in my opinion, at this point, cause the majority to lean more favorably towards the defense. But we still need to see what the defense will say in their closing.
Yeah, Rob, I think you're right that the jurors are going to be thinking about the parents in this case, even though they're not supposed to be thinking about that because this is a civil case against the assistant principal. Let's get to our break so we can get in for the rest of those plaintiff closings, and we should hear the number that they asked this jury to come back with. Stay with us. Let's go back to a Virginia courtroom where we have been watching together the closing arguments in a civil case between a former assistant principal and a former elementary school teacher. That plaintiff's name is Abby Zwerner.
The multi-million-dollar lawsuit stems from an incident back in 2023 when a 6-year-old showed up at school with a gun and shot Zwerner in her classroom. Her attorney says that Zwerner, other teachers, and even students warned administrators, specifically the assistant principal, Ebony Parker, that a gun was on campus.
And Ebony Parker there inside of the courtroom with her attorneys. The plaintiff's attorney is addressing the jury, and we're about to hear the final words the plaintiff has for this panel.
That numbing of life's experiences, numbing of it. What is that? That's not every couple months. I told you I would repeat this. Every minute matters. Every minute matters. When you change a human being, when you change who they are, and you rob them from the control to decide who they will be in the future, you've changed them forever. You've transformed that person. And the Abigail Zwerner that sits here in front of us today, on this day, November 5th, 2025, is not the same Abigail Zwerner that walked into the classroom on January 6th, 2023. Does anybody have a doubt of that? It's not the same person. I'm not saying it's no one anymore. I'm not saying she's any less of who she was. What I'm telling you is that she's been changed and she didn't want to be changed. And what damages do you arrive at? What number do you arrive at for somebody who didn't want this and it's been inserted into her life like a bullet fragment against her spine? Every minute matters. I showed you the video of her laying. You know the video I'm talking about, right? Outside the office. I don't need to show you again, right? I don't need to show you again as she laid in the office and the color that her sister talked about in her face and the light that was in her life you could see was sucked out of her in that moment. And I asked her to step out of this room when we showed that video. I asked her to step out of the room because she doesn't need to see the video to know what that was like. That was her life. She lived it. And just like it might be burned in your memories, do you think it's not burned in hers? And when you think about moments of compensation, what is fair? The question that I asked you to determine is if in that moment, and if in that moment someone came to Ms. Zwerner and said, Abby, this is what you're about to experience. This is what we're going to put you through. There's going to be a boy's face you'll never forget. It's going to come to you when you don't want it to. And you're going to be walking down a hall and you're going to be thinking you're on your way to heaven. And then for a moment, you're going to think you're not going there. Until you're shocked back to life with the pain and pressure of a colleague trying to save your life. If I stopped this case right there, if we stopped it in that moment in time, at 1:59 in the afternoon on January 6th, do you think that Abigail Zwerner would trade any amount of money and say, yeah, I'll go ahead and experience that? That moment that I thought I was not going to heaven, that my faith had failed me, I'll trade that for $10 million? Do you think she would trade it? She wouldn't. She wouldn't for a moment, but your job is the difficult one, which is to say how much would be fair in full if she had to take a trade. If a trade was forced upon her, what would be the fair amount of money? Because that's what's happened. It was forced upon her, and you have to decide how much would be close. And not just for that moment, but for the next, and the next, and the next. And the moments where she wakes up in the middle of the night, thinking of that exact moment, reliving it again, like it's playing on the screen in front of you and she doesn't need to see it. What is that worth? There are some holes. I told Miss Toscano not to get too close to me, but it reminded me of something. We've all had that moment where you're getting a cold. You can feel it coming on, right? You can feel the tickle in your throat. And it's coming to you and you're thinking, tomorrow, probably not gonna feel too good. My nose is gonna start to run. Next day, I may have a cough. I'm gonna stay away from people. Next day, I'm gonna feel worse. My head's gonna hurt. But what we have when we have those colds is that we know that one day will come, whether it's tomorrow, the next, or next week, that we're going to throw our legs off of our bed. We're going to sit at the end of it. And you're going to go, it's gone. I don't have it anymore. It's not with me. She will never have that moment. As much as she wishes to escape in her dreams and escape in real life, every time she throws her legs off the bed, that will be with her forever. And every time she sees somebody reach their hands in their pockets, which I've tried to be conscious of, will be picking a scab at a wound that will never heal. It is for all these reasons and for all of these moments that when you sat here a week ago, I asked you that we would be asking you for a verdict for $40 million. And if the evidence supported it, could you return the verdict? It is because she will never be the same. And somebody might say, they might say, that's a lot of money. It is a lot of money. I agree. But do you think for a moment she would trade it for what she's endured? If we could tell Abby to walk out that door right now, and her sister could look in her eyes and talk to her again, do you think she would trade it? This is the final thing I'm going to talk to you about. When you get back into that deliberation room, I want you to remember our conversation in jury selection, and I asked you about rendering a verdict based upon sympathy or not. You remember that conversation? And I said to you, it's not supposed to be based on sympathy for her, but it's also not supposed to be based on sympathy from Dr. Parker. Because when you go through this calculation and you decide what all of these harms and these losses and what's been taken from her is worth, it's not up to you to decide where the money comes from. It's up to you to decide what it's worth. What it's worth. And if you get back into that deliberation room and there's a conversation and somebody says, well, what effect will that have on Dr. Parker? Or how will she ever be able to pay it? And if for those reasons you reduced your verdict, the number might be correct. Whatever number it is that you decide in that moment might be correct. But it would be the right verdict for the wrong reasons. Because the only reason that you can reduce the amount of what it's worth to her is if you decide it's not worth as much as what we're asking. And that's a critical point, because at the end of the day, what we want is a right verdict, but we want it for the right reasons. Because if it's full justice. Whatever full means to you, whatever you decide full is, that is full justice. And any centimeter or sip less than full justice is injustice. And injustice anywhere is a threat to justice everywhere. And so when you decide this case, when you analyze the facts, when you consider all the evidence, and you decide what's full and what's fair, I'm asking you, and I trust you, to render the right verdict for the right reasons. Thank you so much for your attention.